Hi, everybody. I wanted to talk you through some of my notes for Chapter 1 of Employment Law. A good place to start is to ask ourselves, why are we doing this? Why are we taking this class? Why is employment law even necessary? Which I think is a very good question. So, first of all, we have to understand that individual people, and sometimes people are considered to be companies as well, have the freedom to form contracts with one another. And for the most part, you can do just about anything you want to. I agree to do some labor for you. You agree to pay me some money. I agree to sell you something. You agree to pay me some money. So these are common examples of what contracts might be. However, there might be some things that we don't feel comfortable having people form contracts for. For instance, forming a contract to kill somebody. That's obviously something we don't want to happen in society. So the government steps in to place restrictions on some of the things that we would form contracts for. And that's certainly the case in employment law. Do we think that regulation is even necessary? So if you're a pure free market thinker, then you might think it's completely unnecessary. The efficient market hypothesis would say that if people are doing things they shouldn't be doing or things that are bad for society, their business will falter, they'll be weeded out of the marketplace, and that makes everything more efficient that way. However, the opposing point of view is that since market forces don't always act that way, a lot of times I'm faced with two equally qualified applicants. Some perfections in the marketplace can allow even a discriminatory business to still be successful. So that's sort of the beginning, sort of setting the landscape for you. Is regulation necessary? I'd love to think that it isn't. However, based on what we see in society today, we probably still do need some regulation. And then that's where this class steps in, is to look at that regulation. What is actually required of businesses now? Where do we think that's going in the future? And there's a little bit of interpretation there. Now that we understand a little bit more about why we're here, we move into what we call the agency relationship. Now, this is an employment relationship that evolved out of a traditional law of master and servant, which was a British system in the 17 and 1800s. Now we call it the law of agency. And so what that means is that an agent is hired to represent a principal. In other words, an agent would be an employee while a principal is the employer. Agents act in place of a principal. Agents are, or employees are agents of the employers. And here's where we get a big concept in employment law. Employers are vicariously liable for actions of the employees. So this is a huge concern for employers, because as an employer, you could be vicariously liable for actions of an employee. If somebody, for instance, gets hurt, or if somebody suffers monetary damages and they sue because of one of your employees' mistakes, it's very likely that you as the employer could be on the hook for those damages. Having said that, agents have the duty to act only as authorized. So if I am an employer and I'm trying to figure out how to maybe get out of having to pay damages under a lawsuit, or if I just don't think I really should be responsible for them, we have to look and see, well, did the employee actually act as authorized? Or a common example of not acting as authorized is if somebody is under the influence of drugs or alcohol. Then as long as I've put in place some training explaining to them that they are not supposed to do that, I might be able to escape some of the liability for that. It's not bulletproof, but at least it gives me something to argue in court. I, as the principal, have a duty to exercise good faith in my relationship with my agents, with my employees. I try to protect them from coming into harm. There's lots of laws that we'll get to later under OSHA to provide a safe and healthy environment to work. So that's a little bit about the agency relationship. Another big issue in the employment environment is how you classify the people that are working for you if you're an employer. One of those big ways to classify people is as an employee versus as an independent contractor. Oftentimes they're just called 1099s because that's the tax form you use to pay them. So there are some distinct advantages to classifying somebody as an independent contractor. Among those is that I don't have to worry about payroll deductions. If I hire somebody as a contractor, I just pay them a set amount, $10,000 to renovate this room or whatever the contract is, and I just pay them that flat fee. Whereas if somebody is an employee, I have to worry about paying Social Security and Medicare and unemployment insurance and a host of other things that make it a little bit more of a burden for the employer. Same thing with employee benefits. I don't have to provide any benefits to an independent contractor. When it comes to discrimination and affirmative action, generally the case is that the people that are employing a contractor don't have liability for employment discrimination and affirmative action if there's any kind of affirmative action plan in place. But that doesn't mean that there's not protection there, because the independent contractor themselves probably is going to have liability and responsibility not to discriminate. So looking at this, we can see the advantages to hiring an independent contractor. That doesn't mean it's always the right choice. Oftentimes it is better to have an employee. The big case usually revolves around the amount of control I want to have over the people that are doing the job for me. So looking at some of the cost reductions for hiring somebody as an independent contractor. So we talked about the less payroll taxes that I have to pay. There's also other costs associated with having HR to hire and train people. I'm not responsible for overtime. I don't have to provide tools. I don't have to provide training. I don't have to provide travel expenses. Again, I just pay them that flat fee. Some people say it's an advantage that the employer is guaranteed satisfactory performance on the contract. So if I'm not satisfied with what they've done, I can demand that they go back and fix it and don't have to pay them extra for that, or that might not be the case with an employee. Some people also make the case that independent contractors are more efficient way to get things done due to the freedom that they have. You may or may not agree with that. So what we talked about earlier in the agency part also is that if an employee messes up and I'm the employer, I probably going to have vicarious liability if they mess up and if somebody suffers some type of injury or loss that would result in some monetary damages. However, if I hire somebody as an independent contractor, probably part of the contract that I sign with them is going to ensure that I'm not responsible if they mess up, and that they would have the liability as opposed to me, the employer, hiring them. So as you can see, there are several advantages here, as we've been talking about. One of the disadvantages, and what I don't want to do, is get wrapped up in whatever advantages there might be in hiring somebody as an independent contractor and misclassify them. So we see these lawsuits from time to time. There's been several in the news over the last couple years where an employer misclassifies an employee as an independent contractor to try to gain those advantages that we just talked about. But the problem is that when you are exerting too much control over the people that you've hired, the IRS might actually classify them as an employee as opposed to an independent contractors. If that's the case, and if the government finds that I have intentionally misclassified somebody, I could be on the hook for some pretty big penalties from the government. If you look at the notes in Blackboard, you'll also see a link to some IRS documents for paying out taxes. So what if I'm an employer and I'm not 100% sure whether or not somebody should be an employee or an independent contractor? Maybe I've hired somebody as an independent contractor for several years, and now there's a possibility I may have misclassified them. There's a safe harbor provided for me under Section 530 of the Revenue Act of 1978, which gives me a little bit of protection as long as I'm acting reasonably. if I've been acting reasonably, and if I've misclassified employees as independent contractors, then I might get some flexibility, a little bit of leniency under the law, and allow me to either keep hiring them as independent contractors or allow me to switch them over to employees without suffering a lot of penalties. So there are some stipulations there. I can't have ever treated them as an employee before as far as taxes go. Everything that I'm doing on my tax returns have to be consistent with them being an independent contractor. Everybody else at the company that's doing a similar job also has to be classified as an independent contractor. And I do have to have some type of reasonable basis, or I'm relying on a court decision, or I'm relying on some piece of legislation, or I have to have some good reason for treating them that way. There's also the IRS also has a voluntary classification settlement program, which is another way that I could reclassify somebody as an employee, again, without suffering some of those penalties under the government. You can learn more by clicking on that link. So to the issue of determining whether or not a worker is an employee or an independent contractor, there aren't always a lot of good, solid answers to that question. Some of that's by design. But the basic idea and the leading test right now is what they call a common law agency test. And the big issue there, like I said before, is about control. How much control am I exerting over how the people that I hire are doing that work? Am I providing them tools? Am I providing them training? Do I get to tell them exactly when they need to be there and exactly when they can leave? The more control I'm exerting, the more evidence tends to mount for that person being an employee as opposed to being an independent contractor. The IRS also has a marginally useful test, what they call the 20-factor analysis. You can learn more, but there's 20 factors that they weigh to try to look at and analyze whether somebody is a independent contractor or an employee. And there's different categories that they classify those 20 factors under. But again, you can learn more on those links. Finally, the economic realities test looks at whether or not the worker is economically dependent on the business that they're working for, or are they actually in business for themselves. So this test again comes back to that issue with control, looks more heavily on does the worker, in this case if it's an independent contractor, would they be okay if they lost this one contract with this company, or are they completely dependent upon the one company they're contracting with? And that could be a factor that goes into it, and that test is used for the Fair Labor Standards Act, which again we'll talk to a little bit later. So now that we've talked through a little bit about classification regarding employees and independent contractors, we consider the question about staffing firms, which are more and more these days a popular option. It allows some employers to avoid some of the hiring, interviewing costs. We push that off on a staffing firm who handles that part. Then they bring me candidates and I hire people on that way. So would they be considered employees? The answer is it really just depends. There's a little bit of a difference between just temp workers or just a pure staffing firm where I'm hiring full-time employees. So it kind of depends on what kind of firm I'm working with, who's actually doing the controlling, who's paying people, who's training people. It could be the case that both the staffing firm and the client would be considered employers. And if that's the case, it exposes them to what we call joint and several liability, which is a legal concept that means, let's say there's a dispute and somebody sues somebody. I could sue them jointly and try to get monetary damages from both of them, or I could sue both companies individually. Here we call it severally, and try to get money damages out of each one of those firms. So we move on to trying to nail down a definition of who an applicant is. So like a job applicant. And Again, it's kind of a fuzzy concept. There's not always a firm, definite definition. Traditionally, what we've said is somebody who indicates an interest in being considered for employment. And whether or not somebody is defined as an applicant can have a lot of implications later on. Let's say if somebody applied for a job, they didn't get the job, and they think it was because of some type of unlawful discrimination, we first have to consider, would they actually be considered an applicant? And then that has a big effect on whether or not they have standing to sue. So if the person just emails an employer and says, here's my resume, does that count as a job applicant? Probably not, especially if the company didn't have a job posting out there. It could be different if they actually had a job posting out there and the person responded by sending in a resume. If I just post a resume out there on monster.com or one of the other third-party job boards, does that qualify me and make me an applicant? For legal reasons, probably still not enough there. Unfortunately, we don't have a whole lot of guidance. The EEOC was working on a definition, and they were going to give us a little bit of guidance. They ended up retracting that definition that they were considering. So every now and then we see a lawsuit where somebody's suing and the court analyzes this question of whether or not they were an applicant. And that can give us some guidance, but again, it all depends on what court's considering it. Is that court in the same jurisdiction as I am, as to whether or not that actually affects me? So it's not always the easiest question to answer. The time when it's easiest to answer whether or not somebody is an applicant for a job is when an employer posts a position out there. They have a formal process that you go through where you fill out their application, or you go through their system to submit your resume and cover letter. Then it's very easy to determine and say, yes, this person is definitely an applicant. When it gets outside of that system, that's when it's a little bit harder. Now that we've spent a little bit of time on defining applicant, let's look at and see if we can define who is an employer. And so when you ask whether or not somebody is considered to be an employer, it really depends on what law I'm trying to sue them under. Different laws can have different definitions specific to that piece of legislation regarding who counts as employers. Under the Civil Rights Act of 1866, anybody who hires anybody else is considered to be an employer. However, that changes pretty dramatically once we get to the Civil Rights Act of 1964. So Title VII of that Civil Rights Act of 1964 regulates a lot of the employment environment regarding protected classes and unlawful discrimination. So under that, somebody is considered to be an employer if they employ 15 or more employees for each working day in each of 20 or more weeks in a calendar year. So a lot more specific than just saying anybody. There are some exemptions to that definition. Government-owned corporations, Native American tribes, bona fide private membership clubs are exempted from that definition. And we'll talk about those exemptions more a little bit later in the class. So if we talk about Title VI under the Civil Rights Act of 1964, we extend Title VII protection to any program that receives federal financial assistance. States and state agencies are covered under the Civil Rights Restoration Act of 1987. Under the ADEA, which covers age discrimination, that was passed in 1967 to add age as a protected class, but only to employees who are over the age of 40. So that definition is, rather than 15 employees, it's 20 or more employees for 20 weeks in the current or preceding year. Under the Americans with Disabilities Act, somebody who has 15 or more employees. If I'm talking about the Fair Labor Standards Act, well, now we have to ask ourselves another question, whether or not we're having enterprise coverage, or if we're talking about individual coverage, that can determine whether or not they're considered to be an employer. If we're talking about the Rehabilitation Act of 1973, it's anybody who receives federal funds and government contractors are included, any program and activity of any executive agency, as well as the United States Postal Service. So the summary is defining whether or not somebody's employer is a key part of any lawsuit if there's a dispute, because we have to label the employer and say, yes, under this piece of legislation, they are considered to be an employer. That gives me standing to sue. So that's why we talk about it. Covenants not to compete. We usually just call them non-compete agreements, or non-competes to be short. Were originally developed for high-level members of an organization, think like CEOs, CFOs, to keep them from quitting one company, going to work for another company, and harming the competitive position of the first company. So an interesting development is that over the years, lately, we've seen non-competes trickle down to even mid to low-level employees at companies. So some of you may have even had to sign a non-compete when you were hired at the company that you work for. The basics is that it's okay, at least in North Carolina it is, some states like California it's not. It's okay to contract with a company and say that if I quit or if I get fired from this company, I agree not to work for some type of competition within some geographic area for some period of time. And as long as those elements are reasonable, then it's enforceable in the court, and I would actually have to live up to that restriction. The key is I have to be reasonable with regard to time, distance, type of work performed. If the court deems it to be unreasonable, then the court will refuse to enforce that non-compete, and then I'm able to go work for whomever I should choose. We should not, as a philosophical thing here, we should not prevent an employee from earning a living. Sometimes judges will take mercy on somebody just because enforcing the non-compete would just make it too hard for them to go out and provide for their family. I also shouldn't exceed what is necessary to employ my legitimate business interests. So if I only do business in North Carolina, I really shouldn't restrict somebody from doing business, let's say, in Virginia, where it's not going to affect my business interests at all. The theory of inevitable disclosure is an interesting concept in legal thought. The idea is that I could prevent somebody from working for another company for the competition under the idea that it's inevitable that they would disclose some type of secret proprietary information, some type of trade secrets that make my company successful, and I don't want that to happen. So even it's been the case sometimes where even if a non-compete contract doesn't exist, if there's an imminent threat that trade secrets could be revealed, I can petition to the court to try to prevent them from working for the competition under that theory of inevitable disclosure. So, like I said earlier, non-competes are legal in North Carolina. They have to be in writing, they have to be signed by the employee, and consideration has to be given. If you remember back from Business Law 1, consideration is defined as being something of value has to be exchanged for that. In North Carolina, that something of value can be the offer of employment if I've never worked there before. It could be if I'm already working there and they want me to sign a non-compete, maybe they give me a little bit of extra money or some more vacation time or some type of other benefit, but some type of consideration has to be exchanged there. What do courts look at in North Carolina when trying to determine whether or not a non-compete is valid? The scope of the restriction, what are they preventing me from doing, what's the geographic area? So what was the area actually assigned to the employee? Does that fall within the scope of what they're trying to restrict? Where did I actually work when we're looking at that geographic area element? Where does the employer actually operate? Again, with that geographic element, what's the nature of the business involved, and what's the nature of my duty as an employee, what's my knowledge of the employer's business operation. These are things that the court will look at to try to determine, are they going to actually enforce this non-compete agreement? So just to give you some examples in North Carolina of things that courts have found to be reasonable or unreasonable regarding non-compete agreements. So first, examples of things that have been found to be reasonable: a 2-year 25-mile radius restriction against a general surgeon from competing with his former hospital. Found to be reasonable because 2 years falls within that reasonable time frame, and 25 miles reasonable for a geographic restriction. Also a 3-year 15-mile radius restriction against a dentist for competing with his formal dental office. Again, 3 years determined to be a reasonable time, 15 miles determined to be a reasonable geographic area. This is common when somebody sells a business. So it looks like here, maybe even somebody sold an office. Maybe they were just working for a dental office. But let's say I create a business and then I sell that business to somebody else. It would be very common for me to have a non-compete agreement with the person who sold the business, because I don't want them to sell me a business only to move 2 miles down the road and open up a competing business. That would not be a good situation for me. Finally, a 1-year 2-state restriction against a former employee from working in a specific industry because the employee knew sensitive information in those 2 states and his job was identical to the one with the former employer. So all those were considered to be reasonable. Examples of things that have found to be unreasonable: a 3-year restriction against a caregiver in the mental health industry. The court did not enforce that one because they cited an extraordinarily high turnover of employees in this industry and said it's a little bit too broad there. You can't just restrict somebody's from being able to compete just because they say there's extraordinarily high turnover. That wasn't a good enough reason for the court. A 3-year statewide restriction against a former car wash employee from working in a similar employment. The reason the court struck this one down is because it was a statewide restriction, and the business only did business in the southern half of the state, so it was too broad. Why would you have a statewide restriction when you only do business in the southern half of the state? Finally, a 2-year restriction against a software architect from working directly or indirectly owning or in any way participating in any business similar to the former employer's software business in the Southeast United States. The court just thought this one was way too overly broad. You need to be pretty specific. You need to be reasonable if you're going to have a non-compete agreement, and that was just way too broad for the court to feel comfortable enforcing.